Welcome to the Centre for Legal Innovation's Legal Techy Tuesday series. We are very excited to have Charlotte Agnew-Harington and Ben Morgan from CODR here with us today. Charlotte is an employed barrister and Ben is the operations officer with CODR. They will be demonstrating CODR's fast and cost-effective online legal platform. Again, welcome. Fabulous to have you here. And now over to Charlotte and Ben.
Hello everyone.
Hi.
My name's Ben and this is Charlotte. We work for CODR, or Complete Online Dispute Resolution. And like Christina said, I'm the operations officer. I've been with CODR now for probably a year, around to this date almost. And prior to CODR, I was a police officer, and now I'm also part-time studying law at the University of Auckland. And Charlotte?
I'm an employed barrister. I'm not actually employed by CODR, but employed by Michael Heron QC, who is the founder and owner, operator extraordinaire of CODR to date. And so I'm essentially a barrister doing a lot of various different things, not necessarily relationship property, but a variation of criminal and civil matters and all kinds of fun things. So it's good to be with you today.
Cool. So as you can probably tell from the advertisement and the slides, this is about how we've sort of adapted to a new era in our operations in the past year. We will talk about what we actually do and have done, how we've done it, how we're doing it now, the impact of the infamous COVID-19 on forcing us all to stay at home, how our fixed fee model works, which is often a question we get, and the technology we've used and continue to use. So what does CODR do? When Michael Heron founded CODR, it was generally all about online dispute resolution, as you can probably tell from the name. I suppose what that means is mediations and arbitrations and trying to find a good middle ground between not going to court, but resolving a dispute in a timely and costly manner. As it is in Australia and New Zealand, the court process is slow, costs a lot of money, and generally people just avoid it as much as they can. And part of our offering was to basically move the mediation and arbitration process online. And so what we used for that was this technology, which at the time was called Sweetbox and is now called and has been rebranded to VideoSign. I believe it's a UK-based company.
Yep. Okay.
And what they offer is similar to what we have here at Zoom, which is you have the screens of the people on the sort of right, and in the middle you can obviously share what you're looking at. And we would sort of contract an arbitrator or mediator and invite the parties into this room, and they would open up the whatever needs seeing and speak to the clients through it. And I suppose that the real advantage of the platform and the software was that you could sign online. And I think Charlotte has a better grasp on what that signing process was.
Yeah, so the platform essentially provided us with a solution for conducting online disputes. We would engage the mediator or the arbitrator with the agreement of the parties and proceed to do the whole thing online. So you have no offices, no meetings, no in-person engagement really, other than via email or via the platform. So it allowed you to go on, upload a document, whether it's a settlement deed, a lease, a contract, anything it might be, and everyone looks at it all at the same time. And then when the time comes, if you are settling or you're doing something where you need that interactive signing facility, we have technology that actually allows you to sign online in an environment where your signature becomes encrypted. So it's completely secure. And not only that, but while you sign, or while your client is signing, the system is recording in real time a video of the signature process and also taking screenshots, so that you're able to see at any given time during that signing process what is on each side of the camera. And so what you essentially get is screenshots appended at the back of the document that show what is on my screen, what is on your screen. So essentially you find out who's in the room, and what are they both looking at the same time, what's the document, and where's the signature going. So the technology had a lot of layers of protection, really, to ensure the legitimacy of a signature, which is not necessarily crucial when you're in that online space, but for our purposes, I think it really helped give a sense of legitimacy to the whole process. And people quite often say to us, but it happens online, how can that possibly be legitimate? And we actually able to say with quite a lot of confidence that actually you've got a lot more protections and a lot more layers of insulation from what's I'm looking for, from challenge in an online platform than you did in real life. So we think in a lot of ways it's more secure than putting pen to paper. When that comes at the end of the dispute resolution process, but that's a really key part of what we have moved into doing now, which, as Ben will explain, is more to do with the relationship property agreements that require signature and certification under New Zealand law to actually be valid and binding.
So basically what happened was, providing, as you can see on the slides, online dispute resolution proved to be quite a complex task. A lot of moving parts, quite difficult to get everyone sort of in the same room, interestingly enough, but on the same page and agreeing to dispute online.
Or mediate and arbitrate in general. I think we've got listeners or viewers from Australia and New Zealand, and our experience has been that there's slightly better uptake or appetite for mediation and arbitration generally in Australia than there is in New Zealand. So we've got a slowly growing market, but in general, people were a little bit reluctant, in our context at least, in New Zealand, to mediate or arbitrate, let alone do it online. So COVID changed that a little bit, but our experience was that it wasn't necessarily hitting the right points or providing the right service.
And that led us now to team up with a mediation. Those from Australia might be more familiar with them, but they're basically branching out into New Zealand too, and I believe they're doing really well over there, providing the online side of dispute resolution. There's an amazing software that just works wonders, and so we've teamed up with them to continue offering that in New Zealand. However, again, as part of our original focus, we sort of kept encountering relationship property disputes in New Zealand. The family court, as it probably is in Australia, is just inundated. It is slow. It takes 2 years at least to get anything done. And obviously that includes money and all of that. And those are sort of the disputes we were encountering. And I guess out of the lessons we learned, the area of relationship property became our main focus at CODR. And what I mean by that is, originally and always we have offered relationship property and separation agreement templates. Effectively what that is, if you're not familiar, is a prenup or a postnup, as some like to call it. And you purchase the agreement through our website, and it redirects you to this software company called Automio, and you go through a bot-like process of effectively fill in your name, fill in your nickname, and you build your very own agreement. And we'll demonstrate that later. And that is our primary offering now. And sort of inclusive in our offering is the provision of 2 independent lawyers who certify the agreements. And I suppose what has drawn us to that is A, that we get a lot of uptake on it, but B, we find it very practical in a sense that we offer them an agreement that would originally have to get a lawyer to make them a bespoke version of, and we help them formulate what they want in that agreement, and then we provide the 2 independent lawyers to certify that agreement. And part of that is the fixed fee price. But first, we'll talk about our process in general. So as I said, a client would go onto our website, purchase an agreement through it, and complete the online questionnaire. They receive it once they're finished, they receive it in a Word format, so it is just fully editable as any Word document is. They can contact me or Charlotte for guidance and support on it, or Mike, who's also there. And basically what we do is offer very minimal amendments to make it, how would you say?
I'd say we offer high-level assistance with the drafting rather than actual legal analysis or advice. At that stage, it's really about tweaking things and making sure that the parties are clearly and appropriately expressing what it is they're trying to achieve. Obviously, you have in some ways taken the legal drafting process out of the hands of lawyers and put that process into the hands of lay people. So you inevitably need some support just with that process to make sure we're putting the the dots on the I's and the crosses on the T's in all the right places. So we just help them do that. Obviously, it's quite a difficult time for people too, particularly in the separation agreement context. So sometimes it's just a little bit of hand holding, not to say it's going to be okay with your separation, but just to say that this process is easy, it's doable, and it's not going to overwhelm you. So it's about the drafting help, but also just the support to say this is actually doable, which is really important for our customers.
Yeah, and I think Charlotte, raised a good point about it being doable. Part of our sort of framework going into making this offering is, I suppose, breaking down what we would consider traditional legal barriers, which are just the cost is obviously a big one, time, the lawyer's office. We find that particularly people who are younger are reluctant to go out and step into a lawyer's office because they just don't know what they're getting themselves into, especially when the fee comes at the end of the month. As we sort of know, it's just, you don't know what you're paying, you don't know where it's coming from, particularly for the lay person.
And you've got to find parking too. So we are in central Auckland. People love any excuse not to have to go find a car park. And
I suppose that was the foundation for us leading into this agreement side of things and making it our sole focus, was we just realized that we can make that process a lot easier, particularly in a situation which is often quite tenuous and highly emotional. Even if it's just getting a prenup, I don't think it's probably the easiest conversation to have, but often it has to happen. And the same as a separation, where often you might think you're amicable or people are amicable, but in the end there's still a lot of emotion there, and no one really wants to get lawyers involved because that only complicates it, or as I say, put it through the complicator. But we do what we can to make it as simple as possible, whilst also obviously keeping the sort of integrity required by the law. And ultimately, once they've finished their agreement, they can take it to their own lawyers and they're gone. We don't hear from them again. Or they can submit it to us for certification, and that's when we go out and get the two independent lawyers, one each for them. And what that looks like is basically they either submit it to us or they're sort of in an ongoing conversation with us, and they ask us if they can get the quote. I will send it to two lawyers who we work with on our team. They're sort of around New Zealand, mostly Dunedin and Christchurch based. I suppose that helps with the cost thing, Auckland prices, And they review the agreement. They will let me know if there's anything they need, for example, disclosure, any minor changes they want, any questions they have. I will go back to the client and I will ask them the questions or get the relevant documents if they have them, and speak to them about what they, why the lawyers need them. And I try my best to sort of translate it into normal speak and help them understand. And once that's done, all things going well, the CODR lawyer will provide a quote. And that is a fixed fee quote which covers the advice, certification, amendments, negotiations, etc. for the client. And both lawyers I contact will do the same and have the same process, and they'll both provide a quote. And once I have that quote, I go back to the client and I offer them that quote, and I say part of the offer is there's no obligation and they can compare it. But generally speaking, once they're at that point, I think the ease of just having two lawyers given to you. But once they agree, we invoice them, and once they pay, we introduce them to their respective lawyers. And from there, I suppose the normal process takes over, where the lawyers take it up and they speak to the client, they make changes, they certify and advise the agreement. And that, like we spoke about before, that's done entirely online through video sign or over the phone. And I suppose our sort of time guarantee is from the moment of payment. We can get it done or completed in 10 working days. Generally, we've done it faster, it's taken longer. Often when it takes longer, it's generally because the clients are either being a bit slow or there's certain things we need that require more time. But on the most, generally we get it done in that 10 days, and that's quite good, and it's something that I think a lot of clients we speak to or potential clients is that, it's not going to bog their life down. Basically, they can continue their separation, for example, get what they need and go without the fear of the cost that comes at the end of the month or the lawyer's office. But as with everyone, COVID-19 happened, and it came as we were hitting our stride, really, with relationship property. I mean, when I say we're hitting our stride, we were moving and it was working really well, and we had our process down and we were really confident and it was looking good and we were feeling good about it. And then COVID, and I suppose by COVID I really just mean lockdown. And lockdown began in New Zealand, and we had a month of staying at home, and effectively everything stopped for the first 1 or 2 weeks. I suppose we put it up largely to do with people adjusting to this new world of being at home, and obviously everyone was feeling it and feeling the impact. We weren't sure what it was going to mean for us. A lot of people keep saying, this is going to be a lot more separations. People can't live with each other for a month and whatnot. And after that 1 or 2 weeks, we did begin to pick back up again. Our flow began. We've sort of made a comeback to where we were at pre-lockdown levels now. But it was slow and it was a bit scary. And part of what we did to respond was make a new offer. And the owner of CODR, Michael here in QC, was asked to certify a document for a friend. I think it was access something with the bank. Basically, they wanted a JP when you'd normally just take it to a JP to get your documents signed or whatnot, but they obviously couldn't leave their house. And we began to offer online witnessing of affidavits and other legal documents and free certification of documents for things like KiwiSaver withdrawals, superannuation withdrawals, or what it might be called in Australia. And that picked up quite a lot of traction for us and kept us really busy, through lockdown. And it had its ups and downs. And I suppose how we made money from it in a way was that when it was a law firm or when it was a legal client and we were witnessing affidavits, there was a quoted fee just as we would with a relationship agreement. We'd quote and they'd say yes or no and would go through basically the witnessing process. And that was when we got a lot of advice on our online process and our signing process that Charlotte was talking about before, which is really interesting. Obviously, COVID forced everything online, everything. and obviously all of our offers were already online, but it still stopped us. It still put us, still made us hit a wall.
Yeah, we had to negotiate or navigate, a lot of rule changes I'm sure would have happened in both New Zealand and Australia. So a lot of procedural rules for courts were being very quickly updated and trying to adapt. And I think in some ways we were really at the forefront of the move to put things online. And so it helped at that stage that we already had quite a lot of experience in how to do this and how to negotiate it or how to sell it. Discuss it with clients and how to make it make sense and translate sort of from the online space into the traditional legal space, which was quite challenging for a lot of lawyers and also for courts and things like that. So that was really interesting. And I think a lot of industry, so banks and other big entities like that, there's a degree of pragmatism that kicked in really quickly. So our agreements have for a long time been being provided to banks on quite a regular basis. It's probably one of the bigger drivers of our business is actually banks requiring separation agreements, relation to property agreements. And so in the banking space, they acted to online certification pretty quickly and pretty efficiently. In the judicial space, it took a little bit longer, but we got there with some amendments to the High Court rules and things like that. But it was a really great learning curve for us as an organisation on how do we adapt and how do we help others, bring them along on the journey with us. So that was a really busy and really interesting period when everything else was, going a bit crazy.
Yeah, a lot of phone calls, a lot of Zoom meetings like this. We became very accustomed to Zoom. A lot of questions from everyone really about how it works. What does online signing actually look like? How do we offer it? What does the technology look like?
Does it have integrity?
Yeah, a lot of phone calls to the court asking whether or not they would actually accept it.
Yeah, it became quite a big issue because then even though, you're moving into online witnessing affidavits, which is very new territory, at least for us, there was still a lot of problems. People who, the elderly, for instance, were a really big market that we couldn't help, and really traditional lawyers couldn't help either because of lockdown restrictions. So it's not a wonder product, and we couldn't solve every issue. And obviously technology fails every now and then, unfortunately. But by and large, we were able to craft a really useful solution.
Yeah, and that ultimately that solution didn't last much past lockdown. It was sort of a lockdown offer, and it worked, like we say, it worked really well for lockdown because it kept us busy. One, had a new offer while everything else was slowing down, and really it was quite good, wasn't it, to have clients who needed their KiwiSaver because they'd lost their job or their business and the bank needed them to go see a JP.
Statutory declaration to access your KiwiSaver, yeah.
And we were basically the only person that could offer it, really.
Yeah.
The only entity that could offer it, at least practically. And so there was, it was quite emotional, even just hearing from people and their stories. And so it became a lot more about just a service for those.
Yeah, in a lot of ways, it was our contribution to the COVID response as a public service type of thing.
Yeah,
but it was really good to be able to offer that to people.
But yeah, like I said, it didn't last, and our relationship property stuff started to pick up again after 1 or 2 weeks, and really we're just back to normal now.
Getting back to normal, yeah. So
often the biggest question we get asked from client, person, lawyer, or anyone is, how does the fixed fee model work? And I suppose we've sort of talked through it generally already, and there might be some questions about it later on. But I think the starting point for it was, as I've mentioned before, just having a very clear price point for a legal service. The mediation, the online dispute resolution was all the same. It was fixed fee quoted prior to beginning. And it just helps provide a lot of clarity around what people are paying for, what they're getting. Certainly creates a certain degree of urgency, because you don't want to be spending a significant amount of time on something that is quoted prior. And what we found and what we've developed is sort of a three-step approach to the fixed fee model, and that what that looks like is basic, moderate, and complex. And the basic fee from our website, you might know, is $1,500 to $1,750 plus GIST, and that is for 2 lawyers to advise, amend, and certify. And sort of how we characterize that pricing level is by assets, and assets generally mean complications in the area of relationship property law, apparently. And a good example of what a basic agreement might look like would be 2 people who just just became de facto or becoming de facto soon. They've been in a relationship for a while, they're moving in together, and one of them has an inheritance or has a certain amount of money from mum and dad, or they've just saved it themselves, and the other party doesn't have nearly as much, but they want to buy a house together. And party A, who has the inheritance, would like to ensure they secure that money if the relationship was to break down. However, simply due to New Zealand law, it would generally be shared if they didn't get a prenup or a separation agreement. And included in that would be normal things like furniture and what else?
I quite often get agreements that include houses, chattels, so jewellery, artwork, cars, boats. It's kind of it. Sometimes you get pets, but the basic agreement is really for sort of your bread and butter type of couple. So you haven't got a heck of a lot of stuff or a heck of a lot of assets. But as we move up the fee structures, when we start to do agreements that do deal with more complex assets, so businesses, trusts, multiple properties or rental properties, other holdings, things like that. Or the other thing that becomes important when you start to move up the fee level too, or for us the complexity level, is the division of those assets. So at least under New Zealand law, the de facto or the presumptive approach is that everything will be split 50-50, but we quite often get agreements where people are making the agreement on the basis that they don't want 50-50. I mean, that's why they're contracting out of the law, essentially. And the extent to which they do that and how they do that has a direct bearing on how complicated the agreement can be, and obviously the advice that the lawyers need to give each party as to the disparity between what the result is under the agreement versus what the result would be under law. So that's really when things start to get more complicated, is when you've got the unequal division of assets at the end, or by the same token, unequal contributions to things like houses and things that Ben was mentioning.
Yeah, and generally our main client focus is amicable relationships where both parties know what they want and know what they want to get out of the agreement. And often when we get into the complex territory, the fixed fee model does begin to take stress and often won't work in some situations where it's just simply too complicated for the certifying lawyer to provide a quote that would encompass everything they need to do for the client, the due diligence and whatnot. And so when it comes to that complex fee, we sort of leave it open, and it's really not what we would consider our target clientele. I suppose
it's rare too. It's rare that we get those kinds of clients coming to us for that kind of an agreement. And I think that's usually because clients with low trusts, assets, businesses, you just have their own lawyers. So most of the time what our model works best for and what it's designed for is people who don't have a lot of engagement with legal practitioners for one reason or another. Maybe they're young, maybe they just haven't had need for it before, and so we are often sort of their first port of call or their first engagement with a lawyer, other than sometimes a conveyancing lawyer. So those people who need that more complex advice, generally they are getting specialised advice from their sort of regular provider. But when we do get those requests, we are able to deal with them either by adapting the fixed fee model to be sort of segmented. So we'll have one amount that's upfront with additional work to be charged on a time and attendance basis, so on the normal manner. Sometimes the lawyer will do the relationship property agreement for a fixed fee and then break out and do other documentation that's necessary, so potentially any trust documentation, and that's the relationship agreement is done on the fixed fee model and the additional work is done in the regular way. But whatever the situation, we do always try and find a solution. Which means sometimes it is referring somebody out, but generally we have ways of working around all those various complexities. And again, it's all about making it easier for people who are inevitably coming to us because they don't quite know where else to go, or don't have somebody sort of in their phone book that they can contact to get this done otherwise.
Yeah, and I suppose included in that is we do get the occasional person who does seem to be more interested in getting around the law than actually getting a feasible and workable agreement. And we often that comes up in that review process, and where we reach out to the lawyer, and the lawyer just lets us know that whatever's happening here is
not legitimate.
Yeah, it's just not okay.
Yeah.
And people just try to do all sorts of weird things, and that's not just to say that this is people just trying to get around the law. There's also times where people try to include basically stuff that should be in a will or
a childcare arrangement, things like that within our legal framework don't really fit within the agreement. So we have to be quite careful in just directing those people that they need to get separate advice or do a separate agreement.
Yeah, and I suppose that's all part of it. And we've recently put out just quick guides on our website as to our process that you saw earlier, and the cost and why you should get an agreement. And we're just sort of hoping that it gives people some indication as to really what we're about, and that we're not really the company to solve these super complex relationship settlements, or where there's millions of dollars on the line or multiple trusts. We will help. It's much more feasible to come to us if it is basic to moderate in the complexity. We handle business assets well. Trusts offer a lot of complication for us. There's always most weeks there's someone with a trust that contacts us, and that is always a niggly subject and something that immediately sort of sets off complex alarm bells in our heads. Another thing that can come up is overseas-based assets, where people have homes in the UK or somewhere else in the world, and they're trying to include that in the New Zealand-based agreement, and it's just not working. But generally, as a sort of general rule, we get people who are amicable, who know what they want, and really, really want it done quickly, to the letter of the law, but they just don't want to feel like they're getting the ring around, because I suppose there's a bit of distrust in lawyers generally, and that just doesn't combine very well with an emotional topic. So yeah, part of this discussion is about the technology we use, and we've spoken about some of it generally already with Automio, who are the software providers for the bots that make the agreements. VideoSign or Sweetbox, who are similar to Zoom in the sense that you can sign online. And we have Microsoft Teams, which is what we generally use instead of Zoom, but we do use Zoom as well. And a mediation software who, like I said, I just think it's great.
Fantastic. If you haven't looked at the mediation, you've got an online dispute, you should definitely check them out. They're doing great things.
Yeah, I don't have much else. It just really is just good. But you'll see from the slide that part of our presentation today is to show one of our flows, and what this is just a test flow, and it really just shows the questions you get asked, what it looks like to go through the process for a client who is buying an agreement, and this is a relationship property agreement. You'll see there's a bit of a blurb at the start, a bit in bold here, take your time and please disclose. That is a recent update. The layperson is often not, I suppose, inclined to include everything, but we really try to push on them to make sure they include everything, jewelry, cars, just so it's clear, just so we know what both people are getting, just so there's not more questions down the road from the certifying lawyers that mean there's more, that it costs more for them.
Well, yeah, but our certifying lawyers will also always, when it gets to their stage of the process, will always ask, is everything disclosed? Is there anything that should be disclosed that hasn't been? Now's the time. So we do take that process pretty seriously. But we try to get as much of the information teased out at the start.
And this is, I suppose this is part of that. And this has been a learning curve for us too, in terms of what we need to put into this to get what our lawyers are expecting. And there's a lot of changes we've made, and they're still ongoing. We're always adding things with questions we get, and new queries that we're like, oh, didn't think of that. We better put that into the agreement. And as we'll go through, I'll sort of point out some of the things that we've changed. As you can see at the bottom, the please note. You'd be surprised how many people buy the wrong one, and we have to refund and get them to buy the other one. But that is all part of it, I suppose. So you'll see how simple it is as we go through. Again, just your full legal name and your nickname, your preferred name. And the reason there's required here is because your preferred name is what populates the agreement. And prior to putting the required there, we often got agreements without names, which was a little frustrating. And then we have party one phone number. This doesn't go into the agreement. Part of this is just showing as allowing us to contact them if we need a number to give to our lawyers. And that just again asks the other party what theirs is. What date did you start seeing each other? Is for the purposes of when you're going to become de facto or married, or if this is in contemplation of that. More general information about what this means. As you can see, some of the things are already done by me. And often the clients have to estimate, and often that part of the process of when it comes back to us is when we sort of talk them through it and as to exactly what they meant, because, you know, generally a standardized question doesn't always get the right result. Just explaining what relationship property is. This is quite important, and it's included as a clause in the agreement. It's just a clause in relation to signing this online, and that it will be signed online. And it does help when the parties actually click yes to this. Sometimes they don't. They click no, and then we have to add it manually. But it is there, and we always get sort of noted by the lawyers when they forgot it. Again, the bold bit, just really trying to push this. Please be specific. Please let us know exactly what your assets are. Explain them. Just often what we get is bank accounts. And it's like, we really need them to give a bit more than just bank accounts. So the first question we'll ask if there's any residential properties and person A's name, and then it'll ask them to put that information in. And then again, do you have any bank accounts in your sole name? Please put that information in. And it goes through a whole heap of assets, inheritance, family home, jewelry, which is often something that is forgotten but definitely comes up, particularly when people have, you know, thousands of dollars worth of jewelry. That would make the agreement certainly more fair if they included, or less fair in some sense. Vehicles, how they're going to be split can be quite important. Often one person is just walking away with a car, but it's quite, you know, cars can be expensive, and it's sort of just ignored that they're walking away with a $40,000 car, for example. Included in that is boats, motorbikes, and whatnot. Again, sometimes it's split. For example, one we had where it was he gets the garage, I get the house. And that's how they split their furniture. But it is important, I think, well, I personally think it's quite important to make sure you're at least talking about the furniture that is worth a lot or has a significant amount of value, fridges, TVs and whatnot. Again, superannuation, KiwiSaver, life insurance, trusts. We try our best to keep it part of, we at least try our best to involve it if it's a question. If we haven't heard about it from the client prior to them buying the agreement, it is good for us to at least know if there is one involved so we can ask the questions once we get the agreement. And this basically just goes through it again with the other party, just the same questions. In a second, I'll show you an example of what it looks like when it comes out. It's just a draft one for Charlotte and I.
The purpose of this is a lot of this information that we're asking for, people either they don't have or they won't want to include. People, ignore me, may not have a student loan, or they may not have a car, they may not have various things, there may be no houses. And that's completely fine. The reason we ask the question is because what we experience more often is not that they don't have things, it's that they have things, they just haven't thought about them or haven't wanted to include them. And the point that we were trying to make to our customers is that, well, the best way to make sure that you know what's happening to that asset is to actually include it up front. And then if you don't actually want to agree on it in the agreement, then fine, we can take it out. But you should at least think about it, be aware of what you've got, have a good think about what's in the garage, what's in the basement, where's my old stuff that maybe I don't use anymore, but I wouldn't want anyone else to walk away with if things got really bad. So actually, while those questions are there, and sometimes, look, we do get a lot of blanks come back, but it's just important that we do have those conversations with the clients, and that they have those conversations between themselves too.
And as you can see, there's a considerable amount more than what you'd write into the bot that comes out the other side. This is all sort of standard template.
Yes, essentially our precedent that has been, I think it's about 20 contributing lawyers over the years that have put efforts into this agreement and the various agreements that we use. And of course, we're always refining our process and our precedents. Every time we do an agreement, anytime we encounter a new issue, there are always tweaks that can be made. And one of the great things about the Automio software is that it's actually really easy for us to amend the bot and therefore amend the output. So we are constantly updating and improving and trying to make sure that our agreements are as robust as they can be.
Yeah, and you'll see here, as I suppose I pointed out earlier, is just that audio-visual link clauses. Just really important to, I suppose, really solidify the fact that this is done online. It's part of the agreement. It's important to the agreement. And I suppose something to mention as part of that is that we do sometimes get agreements that are done by other lawyers submitted to us, and one of the parties just wants independent advice, and they need a lawyer to give them that advice. And what we do is we basically follow the same process of taking the agreement, offering it to one of our lawyers, getting a quote, which is effectively going to be half of the normal quote for advice and certification. And I suppose part of that quote will be the lawyer having to add one of these audio-visual clauses just to shore up the fact that they will be doing their part by that way.
Yeah, so when the customer reaches the end of the bot, they get this Word document, so they can then take it away, they can edit it. We have quite a lot of different experiences, which will be either people will take this and do a hatchet job. It'll take a little while, sometimes to put it back together. Sometimes they won't touch it and they'll send it straight through to us to get a quote and come back to them on the certification aspect. So it really depends. And in doing the bot as well, some people, you can go in and out, you can save and exit and come back later, which people quite often do. That's I think the record for completing the bot process is about 5 minutes, 6 minutes on a Saturday night. So do you. It works with you and on your time frame, and then but once we get it, we try and get it to a lawyer within the same day and with a quote to you within one working day. And that's generally our process, and that's what helps. Ben said that the 10-day time frame comes from the payment for the certification, but we do keep all the sort of moving parts moving quite quickly up to that point as well. So in total, it's always going really quite quickly, unless people want to take their time, which is understandable and necessary in some circumstances too.
Yeah, I think the fastest we've ever taken an agreement from being purchased to fully certified was 3 working days.
And it's important to emphasise that that's because the parties that came to us were completely amicable, agreeable, and they knew what they wanted, and all we did was give them the tools to get there. So quite often what they say is they'll ring us up and they'll say, I need this, and it just needs to be legally binding. It just needs to do one thing, and I need it to be binding. And we can say, yeah, that's exactly what we can give you. And usually it's the house. It's they're separating, or one of them's they're getting a mortgage in their dual names, and one's got the deposit, or they're separating, so one's buying the other out. And they just say, I'm settling on Friday, 2 Fridays from now, or Friday, and I just want it to deal with the house, and that's it. And yeah, and given that it's amicable and agreed like that, we can really turn it around quite quickly, provided we have capacity and our lawyers have capacity. Yeah,
but then the flip side of that is the sort of ones that take 4 months to get over the line, where we haven't heard from them in a long time, and then they sort of crop back up a couple of months later with more information and new changes, and that's fine too. We work with them on that, and that's good that they're putting so much thought into what they need and what they want, and particularly with COVID now, it's sort of changing the dynamics around assets and how things work, and it's good that people are actually spending the time to think about these situations. With the agreement itself, you can certainly tell when it's filled out by only one party, as the other side is just completely blank. But it does really help when they fill it out together. I suppose the iffy thing is when they're separating, they're usually not in the same place. So one party does it and the other one edits the Word doc, and that can come out looking like all sorts of madness. I suppose the big thing I tell people is, obviously they're not going to be able to put it into the technical or legal lingo that may be needed or may be wanted. I suppose I just explain to them, can you just put it into your words so that anyone can understand it? Explain exactly what you want from this agreement, so we know and the lawyers will know that this is what they're trying to get out of it, and what usually that shows exactly what people need to do or what we need to do to get them to that point. And then once it gets to the lawyers will amend and adjust as necessary. I think we're coming to the last slide, which also, I suppose, includes our little announcement, which is that CODR Limited will be transitioning to Agreeable Limited in the near future, hopefully by September.
Got a big exciting rebrand coming, so look out for that.
A website, everything will be changing. I think we're keeping the same colour scheme and whatnot.
The same great service.
Same people, and we're just fine. Agreeable is a much softer name, much more focused on this relationship agreement side of things, and it's actually really exciting for us, isn't it? I think Charlotte came up with the name, and it took a while, didn't it?
Took a while, but we got there, so hopefully you like it.
Thanks, Charlotte and Ben, that was great. So that was an amazing demonstration. It was really interesting to learn how CODR have developed a platform that breaks down the traditional legal barriers and the technology used to do this. It was really interesting to hear of the challenges CODR have faced along the way and how you have worked to resolve them, and how this has impacted CODR's work going forward. A huge thank you to all of you who have attended today. As you know, the Centre for Legal Innovation is very much focused on these types of webinars, this type of information sharing, collaboration and experience exchange. We are all about practical solutions. There will be many more webinars coming up in the Legal Techy Tuesday series in 2020, so don't forget to follow us on LinkedIn, Twitter or Facebook for announcements. We look forward to welcoming you back to one of our events, and thank you again very much for joining us today. Thanks, Charlotte and Ben, that was great.
Thank you.
Thanks, Christine.
Thanks. Bye, everyone.